Thank you. You may be seated. We are here on our case number 1CA-CV150580, Brandon OROSCO et al. Versus Maricopa County Special Health Care District. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us the name, your name and the name of your client. We have reviewed the record, we've read the briefs, we've also discussed the case in our conference. So with that, Ms. Peterson, you may proceed.
Yes, thank you. I would like to reserve 5 minutes. May it please the court, I represent Maricopa County Special Health Care District. We are here today requesting that this case be reversed and remanded for a new trial. The verdict should be reversed on public policy grounds. The appellant in this case was essentially punished for admitting liability. Why would anyone admit liability in an action if that would allow the consequences to be that the other party, the plaintiffs, were able to pile on excessive testimony both on standard of care and on these issues from experts and lay witnesses when these issues were very simple?
But weren't the issues of negligence and liability complicated by the comparative fault question?
Your Honor, the comparative fault issue had to deal with the fact that there was a co-defendant, the physician group in the case. The co-defendant jointly moved with the district to have the court, instead of admit evidence, to simply instruct the jury that you should not leave a 2-foot guide wire in a patient. And then when that is done, the standard of care would be to, as the resident in this case was the one inserting it, to report it to the attending and to report it to the radiologist so they would know what they were looking for on the films. That was the requested instruction. Those are very simple issues. In fact, that rises to the level of cases in which no expert testimony would even be required to insert liability against a defendant healthcare provider. This is akin to burning someone during surgery. It's akin to leaving a rag in during surgery.
I don't see an argument appealing the judge's failure to grant that motion.
Oh, Your Honor, that is part of it. It is all wrapped up in our argument, and it's clearly addressing the fact that in this case, the issues were not such that, given the comparative fault itself, that we needed to have all of this evidence come piling on against the defendant hospital. It wasn't just introducing.
There's some minimal evidence that needed to prevent. You talked about it going to the jury, but how would the jury determine comparative fault between the group, the other defendants, and the hospital? How would they determine that without any evidence of who screwed up? Right?
Well, again, the hospital took the position from many openings to openings all the way through into having the witnesses testify. Dr. Lobo left a guide wire in a patient. That should not have happened. Whether that conduct in relation to the radiologist's conduct in not recognizing it on the films, those were not such complicated issues that required a full-blown trial on all of the facts relating to the defendant's negligence. And what happened, instead of just simply listing it to the issues that required comparison, which is, what did the radiologist do? The allegations against the radiologist were very straightforward. They failed to recognize that on the x-ray. But what happened in this trial, and why we ended up with a 99% allocation of fault to the hospital, was because of the excessive piling on. It was not just the introduction of the doctor at issue testifying regarding what she did. It was not the nurse who was involved that didn't report it to anyone either until months later when the guide wire was actually found. But on top of that, we, as the district, had to deal with, now they're calling expert witness after expert witness to tell the jury about what bad actors we were.
My understanding of the record is that there was just one expert witness called on that.
Unfortunately, Your Honor, there was more than one expert. The record clearly reflects that plaintiff was allowed to call Dr. David Kosman, a vascular surgeon, who, by the way, doesn't even come close to meeting the standard under 12-2604 because he does not have the symmetry of qualifications of this resident. But more importantly, the co-defendant called their own expert, who was a radiologist, who clearly didn't meet the statute.
Well, that's not the plaintiff's problem, is it?
But, Your Honor, the judge's role in this case is to be the gatekeeper, to keep the unfettered piling on. And the two parties were basically in collusion with the piling on. The radiologist expert was allowed to go on and on saying, I can't see how this could happen. If you insert it and you're supposed to be in a vein, how does this end up in an artery? And going on and on about how this shouldn't happen. Rule number 1, don't let go of the guide wire. That came in as evidence clearly addressing standard of care over repeated objections. And then on top of that, as we discussed in the Vargas case, when you have fact witnesses like the other 3 defendant radiologists who come in and they give their views on what should or should not happen, they then turn into, as the court recognized in Vargas, they become experts. They become that impermissible piling on of multiple white coats telling the jury what you did wrong. And that's clearly in contravention of 26B4D.
What were the plaintiffs supposed to do if the 2 co-defendants are duking it out with their evidence? Are the plaintiffs supposed to tell the court, no, don't let them come in? I mean, I don't understand how this can be put at the feet of the plaintiffs.
Well, Your Honor, with
The
all due
problem is the allocation of fault.
Right. With all due respect, it's not just the plaintiffs. The obligation here is of the court to ensure that my client have a fair and impartial trial. And the legislature and the Court of Appeals have recognized multiple times that having multiple people speak to an issue creates prejudice. And here, we're in the framework where the admission of liability has already been made. These are not on such complicated issues that required multiple experts to explain it to them. And in fact, the appellees took the position in their answering brief, no harm, no foul. The jury would have figured this out on their own anyway. Well, then why, dare say, did you call an expert, an unqualified expert to boot? And then the judge's job is to ensure that all parties get a fair shake. So, yes, the plaintiffs didn't create the situation with the co-defendants, but the co-defendants were allowed to call it. And so what we would do is we would create, with the precedent of this case, saying to people, you can call, instead of one expert per issue, which has been the law in Arizona for decades, you can call multiple issues. And we're not going to fault the other party. That's where
Isn't each party allowed to call one expert on one issue?
No, there's one expert per issue, not per party. If that were the rule, then in every case in which there's crossfire between defendants, you would have the defendants naming experts against the other defendants and the plaintiffs, and you'd still have piling on an expert. And again, in the context where we...
Wait, back up. You're saying that the co-defendants have to agree to the same expert?
Even if they're adverse to each other on that point?
And here's how, in practicality, is if you have one expert who's saying it's below the standard of care to leave the guide wire in the patient, that's not even necessary in this case, but once you do that, then the trial court has to enforce the one expert rule and cannot allow the testimony to come in front of the jury, allowing piling on. That's duplicative.
What's a case that says if the co-defendants are adverse to each other, the co-defendant may not offer an expert to testify to the same subject matter as the plaintiff did?
Well, I think that's directly within the rule. And as far as in the cases interpreting this, the most important thing to keep in mind is why do we have this rule? Is because it is recognized that the prejudicial effect that can have when you have more than one person testifying. They can retain other experts, but whether they actually get to testify in front of the jury, that is not permissible. If they're just going to be offering, as this case did, multiple experts that are testifying on the same issue, and none of which who qualify under the statute, it's basically telling the district, if you admit liability, even if there's comparative fault, there should be some limitations on when you go, as in this case, from simply telling them the straightforward facts to putting in all of the experts, all of the fact witnesses, all of the evidence. It then creates a cumulative problem in this case where we're deprived of a fair trial. And then you add on the other errors, including the fact that they were allowed to argue negative inferences from the fact we didn't have an expert. Well, of course we don't have an expert. We had admitted liability. So that was, again, an improper argument that was on top of the fact that there was an IME physician. Of course, under the Lugosi factors, here's nothing unique that our IME expert had as
Well,
far as.
Yeah, he could testify to what happened when someone presses on the plaintiff's leg.
But that's a very simple issue. He
Fine,
had his
but-
own
but
IME
when
expert.
the defendants were complaining that he was overstating his injury.
That was not raised in the trial, that he was overstating his injury as far as when you press on his leg is pain. That wasn't a unique fact at all in the case, such that Lugosi would allow that expert to come in and the negative inference to be made. And what's more problematic, and the most problematic here, is on top of this piling on, in which basically we start with the arm tied behind our back with admitting liability, then we're being beat up on cumulative, unqualified, duplicative experts. Then the plaintiffs go and argue the send a message and conclude their oral argument with tell them with your verdict, this community deserves better. In response to that, the plaintiffs, or the appellees in this case, put forth a case having to do, the Jackson case, having to do with choice of law principles. That has nothing to do with how inappropriate that is. And again, there's multiple cases that we cited that talked about when you have a compensatory case only, like this one, where even if punitives had been alleged, they're not available as against the district, a public entity. But then to argue that it's appropriate because we put it in the context of compensatory damages, that's exactly what the cases that we cited in our supplemental rule of authorities talked about. That is the most dangerous time to argue that, because then the jury would be given the impression that these damages are appropriate. And that's what happens. That's how we end up in a case where we have an inflated verdict of $4.25 million against the defendants. And the reality, the damages in this case were relating to aggravation of the pre-existing injuries. The burn is what ruined this man's life. The burn is what caused him to no longer work. He had a slight aggravation of his PTSD, and he had a slight aggravation of his pain in one leg, but he still would require pain medications. He was never going to go back to work. He was going to have all these issues. And so when you look at the cumulative effect of all the errors in the case, you realize that it got there because of all the inappropriate evidence that came in, including the loss of leg.
I want to ask you a question about the first topic you raised, the assertion that in a case like this, where you have a plaintiff adverse to both defendants and the defendants are adverse to each other, that under the rule, the court may allow no more than one expert on the topic of whether a defendant A is liable and defendant B is liable. How is the court to decide in that situation whether to allow the expert proffered by the plaintiff adverse to defendant A, or to allow the expert proffered by defendant B that defendant A is liable?
The plaintiff carries the burden of proof, Your Honor. So the plaintiff would get deference to their selection of an expert, which is why the rule was amended. It used to say one expert per side, and because of these issues, it now says one expert per issue. And specifically contained within there, it says in medical malpractice cases, there shall be presumptively one expert on standard of care.
But wasn't the point of the radiology expert's testimony to be that that its fault was less than the hospital's fault? Not so much that the hospital was negligent, but it was more negligent than the radiology group?
Well, if that had been the argument and the basis they had laid, that's one issue. But here's the actual testimony that their expert was able to give. I can't imagine a scenario where I would make the mistake of not knowing that, number one. And number two, rule number one on these procedures is never let go of the wire. That testimony he's giving is directly related to standard of care. Number one, on 12-2604, there's no way he should have been able to give that type of testimony. Baker case, the Arizona Supreme Court made it very clear. In a case like this, where it's a vascular procedure that may cut across disciplines, just like they considered in Baker, you have to match the qualifications of the defendant at issue.
You know, I wanted to ask a question about that, which goes to your challenge to the vascular surgeon who testified for the plaintiffs. Is there the problem I have with that argument? I mean, the statute's pretty complicated, but the problem I have with that argument in this case is does a surgeon take out the wire in any different manner depending on what kind of a surgeon it is? The wire needed to go. It needed to be taken out. So why did the defendant doctor have an obligation to do it in any other different manner than what the vascular surgeon did?
It's interesting you should frame the question in that manner, because that's exactly the issue in Baker, is because they had a pediatric hematologist that was the defendant, and the expert retained by the plaintiff was an internal medicine, hematology, oncology. The patient was 17. They all agreed that both doctors could have cared for this patient. They all agreed that the treatment would have been the same, but the court said that doesn't matter because it doesn't meet the statute, because you are not matching the specialties of the defendant provider. And that, in this case, it wasn't even close. He's a vascular surgeon. She was a board-certified general surgeon undergoing a critical surgical residency. Dr. Kosman didn't even know what that was when he was questioned on the stand. And so to allow that to happen in this case, where there were so many rulings to allow in evidence that was not supported by the statutes, not allowed under our basic rules of one expert per issue, that this piling on, it led to then even more piling on. Because the one thing about that save a message at the end of wrapping this all up with a bow is that every single one of my objections was overruled. I didn't have the opportunity to get curative instructions on any of these issues. The court continued to allow this. And when plaintiffs stood up and made their closing arguments and made adverse inferences about not calling an expert and not calling the IME expert and all of these things, and then wrapped it up with the send a message argument. And again, we objected, and the court overruled that. So there was no opportunity. And in this case, we knew that there was a chance that that argument would be made. So we offered a punitive damages instruction to make it clear you cannot find in part of your deliberations punishing the defendant. And that instruction and all the opportunities to cure were not granted to the district because not one of these objections were sustained. Thank you. I will reserve the rest of my time.
Thank you.
May it please the court. My name is Frank Powers. I represent the appellees Brandon, Jennifer, Marissa, Kaylin, and Silas Orozco. It may be that you think the jury could have found the way Maricopa Medical Center wanted, but that is not, the question isn't whether they could have found that way. The question is, did the evidence that was presented permit the jury to find as they did with their verdict? Brandon and his family, they went through a lot, and they're going to continue to go through a lot. The trial was 2 weeks long. The jury heard a lot of testimony and a lot of argument. In the brief, I tried to point out the main points that I think support the verdict.
Well,
trial
talk to us about
transcript.
the one expert rule.
Sure.
Let's talk about that.
As far as the one expert rule, we brought one expert as to the resident, Dr. Kosman. We didn't offer any other expert testimony. In my brief, as I outlined to you as to each of the witnesses and the testimony, I would take issue with characterizing that testimony by the radiologists as standard of care against the resident. I would characterize it as them talking about their standard of care and what they were doing and what they think and their process and the guidelines at the hospital they operate under. And importantly, the one point that is harped on, that the one radiologist said, rule number one is you never let go of the wire. Well, that was a fact in the case. I think pretty much everyone agreed to that. And that wasn't the negligence that resulted in the lawsuit. The negligence that resulted in the lawsuit was after they let go of the wire, they couldn't find the wire. They did nothing to tell anyone else that they lost the wire, and they didn't know where the wire was at. That was the problem. The problem, had she reported it, the whole issue in the case was, had she reported it, then they could have easily found it and easily fished it out, and it would not have had the time to cause all the problems that it did. And so the standard of care issue about never let go of the wire really was a non-issue in the case. And the case really wasn't about, as they're saying, piling on standard of care testimony. I tried to focus almost the entire case on the damages issues, and I brought only one expert. And as far as in the closing, I did not comment at all about all the different testimony of everyone else that she's complaining about. I commented about, I talked very little about the liability at all in the closing, other than I spent a good portion of time talking about the radiologists. Now, I'm not sure.
What about, maybe you're going to go this direction anyway, but what about the qualification of experts issue?
Sure.
I mean, not matching up. How do you respond to that?
Sure.
Or Baker?
Yes. The vascular surgeon that I retained, he was also a general surgeon. As the general surgeon qualifications, he had a board certification in general surgery and vascular surgery up until, and we didn't realize it because he had an error on his CV. His board certification expired, shortly before the time frame right here. But he testified that this procedure that was done was a vascular procedure, and that he was board certified in vascular surgery, and he teaches residents this procedure. This resident testified, the trial testimony, although outside the presence of the jury, I think in discovery, we knew that this resident had a board certification in general surgery. But the resident testified, and what was shown to the jury was that she did this procedure as a resident in this program. And this was a vascular procedure. There was no dispute. No, they brought no one to say that this was not a vascular procedure done by a resident. And the vascular surgeon that we brought teaches residents in California this procedure, and he's done thousands and thousands and thousands of them.
But
And so
wouldn't he be overqualified as compared to the resident? I mean, how can you say he's not? He's much more qualified than a resident.
Well, that's okay under the statute. You can have someone that's more qualified. That's something for the jury to assess.
It doesn't have to match up.
It has the procedure.
I mean, would you be able to find a resident that
Oh,
could
I see what you're
testify?
saying. Did I need to
resident
have a
against
resident?
Basically, I'm talking about not a because the resident is the one whose conduct is at issue here.
But
As far as comparative fault.
sure, but the statute talks about specialties and the different board certifications under ABMS. And the resident wasn't doing this as a specialist, he was doing it as a resident.
And the care, Baker talk, maybe this is the answer. Baker talks about, the statement says, I'll read you the statement. We accordingly interpret 122604 as requiring that a testifying expert specialize in the same specialty or claim specialty as a treating physician only when the care or treatment at issue was within that specialty. So was the care and treatment at issue, I think you're saying it was within the vascular surgeon specialty.
Correct. And a resident isn't considered a specialty under the statute. It's not a board there's no board certification in residency.
So you can get any expert.
Well, no, you have to have an expert that's qualified in the procedure that was done. And this was a vascular procedure, and I brought a board-certified vascular surgeon to address the vascular procedure, who teaches residents. Yeah.
Although not residents in this program.
That
Is vascular surgery residents, right?
in the trauma program. I don't know if it was just that the programs had different. There's multiple programs for residents, I suppose, and he teaches in the residents that came through his program at his university, medical center.
You know, what I keep coming back to in analyzing the qualification issue is that there's no dispute that this was negligent. No one, many different surgical specialties do this procedure, and it would be negligent done by any specialist. Okay, so that tends you to think that, well, this is harmless. It doesn't matter. This is like leaving a sponge in. But then on the other hand, there was expert testimony offered, so I'm kind of having a hard time figuring it out.
Okay. The best way, I think, for me to address that is, I agree with Your Honor. The negligence was admitted, so the result's the same. But the jury, the physician, the board-certified vascular surgeon, addressed to tell the jury what should be done and why. And it was necessary in the sense that it helped the jury understand the causation issues, in that this is what should be done and why. If it's done that way, why you wouldn't have the problems that you have and the injuries that you have. And so we saw it as this is needed to be explained what should be done so that how this harm can be prevented, if you will. And so that's, if Your Honor is wondering, well, why would you even present that testimony if you didn't need to? And it's part of having the jury understand what could have been prevented and what not.
The process.
Yes, exactly, Your Honor. I do want to, if it's all right, just address a couple of comments that I heard today. The defense didn't appeal the allocation of fault. The judgment against the other doctors is final, and so I'm not sure if that's what she's arguing here, if she's saying that this piling on caused a different allocation of fault, but she hasn't appealed that. She's never taken issue with the allocation of fault. I mean, as far as I can tell, she's bound by that final judgment that's been entered and not appealed as far as the allocation of fault with the other doctors.
Well, that's interesting because I mean, if you follow, and I will ask this question when we get to it on the other side, but yeah, let's assume that the court did err by allowing both the plaintiff and the radiologist to offer expert testimony on the standard of care. That doesn't undermine the damages award. That only undermines the allocation of fault.
Exactly.
And you probably don't care.
No, I didn't care. No. And so a lot of what she's talking about exactly deals with something that's not at issue in this case, and that is the allocation of fault between these two. And it wasn't to inflame the jury about damages. Those two were fighting it out about the allocation of fault. And there was something that was very interesting that happened in the close. that I kind of, it kind of struck me at the time, and that was, that was on the 17th in the transcript, page 45, lines 4 through 21. Defense counsel for the hospital said our expert, who said the radiologist should have seen the wire, said our expert was wrong, that the wire was, the radiologist couldn't see the wire. So she was saying that our argument against the radiologist was wrong, and I sat there thinking that pretty much does away with the fault of the radiologist when one defendant is saying that. Then when it comes to I do want to address the closing argument if that's an interest or concern of any of your honors.
Sure.
The closing argument was, from the plaintiff's perspective, focused on damages, said very little about the hospital. In the entire closing argument, there were two objections. One by the hospital's counsel, and that was the one that you see in the briefs where I said conscious of the community. And then there was one other objection by, I believe it was me. And then there was no objection in the rebuttal argument either. When I was before I said the words conscience of community, I asked for the damages instruction to be pulled up, and that's what I was talking about. And the way I interpret the conscience of community statement is, in voir dire, the judge talks about the jurors being brought forth as members of the community. And conscience to me means to do the right thing. And so the way I interpret that phrase, if it's not intended to impassion or prejudice or inflame the jury, and it's not, what I'm trying to do is say do the right thing as to damages and full damages only, and it's not, I did not ask for more than full damages. Like most all the cases, if you look at them, as I tried to cipher through this, where the problem happens with a conscious of community argument is when you're asking for something more than damages, when you're asking them to do something to punish, or you're asking them to give more because of the conduct. And there was nothing like that in this trial. And then because of the one objection, I moved on, and I talked about the other things in my close. There were no other objections, and then in the rebuttal, I changed my rebuttal argument at the end of it, and you can look and see at the end, instead of using that phrase, I just told them to do the right thing, to make sure you've done the right thing, and full compensation for the harm that's been caused. And as far as if your honors are concerned about the amount of the verdict, I'd be happy to address that. I tried to lay it out in the brief. But Brandon, there were five plaintiffs, and Brandon suffered two significant injuries that really worked against him together, that caused a lot of the other additional problems and psychological injuries. He lost the main artery in his upper thigh, and he lost a minor artery in his leg. And so his leg is, dependent upon collateral circulation to be viable. And the more he does with his leg, the better he'll be. But the simple fact is his leg is weak, and it will not get any better. And he has potential for serious infection that could cause, the loss of the leg, or if he lost the collateral circulation, the loss of the leg. But the additional problem is Brandon suffered serious damage to the femoral nerve in that leg, which causes not just a little pain, but mind-numbing pain all the time, which requires narcotic pain medication. And that pain, even with a narcotic pain medication, does not go away. So the more he does, the more nerve pain he has from the femoral nerve. So it behooves him to not do as much because he's just going to have more pain. But the less he does because of the nerve pain, the more problems he has with his circulation in that leg. And it's kind of a vicious circle. And it's the same way it was described by their psychologist that they called. You know, he has pain. The pain causes psychological problems and depression, and all the way to where he tried to commit suicide. And then the psychological problems cause him to feel more pain. And so he's in a cycle and circle, and he's not going to get out of it. And he has all the other problems that go along with taking lifelong narcotic pain medications and what it does to your body. And so this is a very serious, significant injury, and I think we provided substantial medical evidence and factual evidence to support and differentiate the difference of the damages between the wire injury and everything else that they were talking about in the trial with the burns and everything. And even in their opening statement, you know, they said, we all said, the OROSCOs were not claiming harm or damages for the burns or anything else that were going on. And we just repeatedly said that, and they got multiple jury instructions about it. And the jury was very well instructed about a lot of things. I see I'm running out of time. If there's anything else that your honors are concerned about or would like to discuss, I'd be happy to discuss them.
No, thank you. We're good.
Thank you for your time.
Thank you. Thank you.
Starting with the allocation issue. The co-defendant joined in the request to have limited instructions given only for one reason, because they knew and recognized that the piling on would result in an excessive verdict like it did in this case. Our point was, in discussing that and raising it as an issue, was if the co-defendant wasn't to complain about the comparative fault, why does the plaintiff then get to bring in all of this excessive evidence? I've tried 2 cases in which negligence was admitted. The first one, the court was very clear and very careful in leveling the playing field such that the jury had enough information to understand the claims, but did not allow multiple piling on. There was nothing more that they needed past Dr. Lobo taking the stand. Everything that occurred after that first witness was called made it almost impossible for us not to deal with a very inflamed jury. And
What's the argument, or what's the answer to the question that counsel raised about the hospital's failure to appeal the allocation of fault?
The allocation, in all straightforward, with the allocation of fault, the case would be remanded with the understanding that it would be as against the hospital only, and that there would be absolutely no argument about comparative fault. The court precluded us from bringing in the comparative fault of the plaintiff. That was part of the issues in the case. And so that's why we made the decision that we made. But what we're talking about here is a little bit different when you talk about the evidence that came in and how that weighed, because what the message would be sent if we uphold this verdict is, if you're a defendant, you should never admit liability, because basically you're saying your expert qualification statute doesn't matter. You've admitted liability so you can pile on anyone, no matter how overqualified they are. And in this particular case, she wasn't just a resident. This was a board-certified surgeon who practiced for 10 years. The qualifications they needed to match was someone who practiced in general surgery. She'd gone back to do a residency, so her specialty was general surgery.
How do we know that the asserted error in allowing multiple experts on one topic caused the jury to award more damages than it would have otherwise?
Well, I think it's the net result. The net result clearly speaks for itself. The fact that it was $4.5 million, and that was the Vargas case we supplemented.
Wouldn't the natural outcome of the violation of this rule be not affecting how much in damages, but instead affecting the allocation of fault.
Well, it clearly did too. It ended up at 99%. And so the two things that happened here is that we had multiple cumulative errors that occurred on top of an admission of liability where the court did nothing to enforce any of the rules, did nothing to enforce the expert witness statute. And there was a second expert called by plaintiffs who inappropriately, Dr. Stephen Pitt went on to go ad nauseum about how can you leave a wire in someone for 50 days. This shouldn't happen. That's additional testimony that was entirely under the control of the plaintiffs. And yet they allowed that to go on, and they allowed that witness to go on. Why was the psychiatrist even commenting about the standard of care for the resident? It made no sense.
Okay.
And thank you very much, Your Honor.
Thank you. Thank you to both sets of lawyers for your argument and for your briefing. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.